Good evening, this is Pastor Mike, and we're here for another video on the Investment and Truth Review program. The date today is February the 8th, 2019, and this is Pastor Mike of the Remnant Church in Southern Oregon. Now, the title of tonight's subject that we're going to address is Inherent Rights and the Practice of Law. It will be done under, we'll get this over with real quick. It'll be done under code 0004 2019 V for video on February the 8th, 2019. Okay. We got a lot of ground to cover, so we're going to go ahead and get into it. I want to mention something for you because, you know, sooner or later people will figure it out anyway. And that is that I used to be on pain medications through the VA. I was on it for years and years. And the VA, in its infinite wisdom, took me off of the pain medication. And now I'm in pain off and on, mostly more on than off, a lot of the time, and it affects my concentration. And you might have noticed that sometimes I have a little bit of trouble concentrating during a video. It's not that it's a real big problem, you just have to bear with me. You don't have to worry about it. I mean, you know, I'm used to dealing with it, but it does have a little bit of effect on the way I perform. You don't notice it when I'm doing written work because it doesn't show in written work, but this is me in person on video, and you might notice. So I thought I'd mention that, get it out of the way. Okay, what we'll be talking about today in the subject matter of inherent rights and the practice of law. Okay, well, we're going to be talking about, first of all, what I wanted to do here tonight. The last couple of videos I did, they were really structured and based on intense notes. I'm trying to get away from that a little bit. Not that we're not going to have notes, we're still going to have an outline to go by, because you really can't do one of these properly without an outline and some notes. But I want to lean a little bit towards spontaneity of presentation. Also, I do have to read a lot from documents through these tapes, and just bear with me on that. We have to do it. I'll try to be more spontaneous and not always have to read. I'm looking down, of course, at my computer screen. That's where the notes are, so it may look like I'm looking down, but I'm just reading the notes. So I can't look straight into the camera all the time. Okay, we're just going to see how that works. We're going to check out the video after it's made. If it's doesn't come out right, well, of course, then you'll never see it. If it does pass muster and it goes ahead and gets released, then maybe you'll see where I strayed a little bit and perhaps messed up a little bit here and there. I'm not really trying for an Academy Award here. I'm trying to give you information and make sure that you receive the information. That's what we're doing. So you might wonder during the presentation that we're going to make, you may wonder at some point that you'll say, well, why is he talking about all of these issues that don't seem to be related to the issue of inherent rights? And I just want to tell you that we are addressing the pursuit of inherent rights, and I can assure you that we're going to get there, but we have to cover some areas that appear to be unrelated. Believe me, they're not unrelated. Okay, we're going to go straight into the disclaimers that I always have to read and get that out of the way. So I'll go ahead and read that. The information provided herein is for educational, truth, and knowledge purposes only. No specific course of action is directed except the advancement of knowledge and truth. I now state and clearly declare that I am addressing the subject matter set forth herein as a pastor of God in my religious and ecclesiastical capacity and office, and that I am exercising my official function to keep religious believers informed of their various rights, freedoms, and liberty under God and relative to their awareness and understanding of the various laws of man. Therefore, I hereby declare, claim, and assert any and all religious protections of whatsoever nature and kind, including protection from discrimination on the basis of religion, available under the inherent, inalienable, primary, and subordinate rights and laws. The Remnant Church in Southern Oregon, Michael Benjamins Jr., pastor, in both his personal and ecclesiastical capacities, including his subordinates and personnel, individually and jointly disclaim any and all liability and or responsibility for any damages sustained or suffered by the reader or other entities, reader or viewer, of course, in the implementation of the teaching set forth in this treatise or video. The material is provided as a research study project for learning purposes only, and the implementations and or applications, contrary to my cautionary warnings, which I will state from time to time, are undertaken at the sole risk and peril of such readers or entities or viewers, of course. No statement is made or implied as to the ultimate outcome resulting from such implementations and applications. Okay, that closes out the disclaimers. Now we will go on. What we're going to start off with here is we're going to talk about what is the practice of law. And it gets kind of complicated in some ways and simple in other ways. I'm going to start off giving you the simple answer. The practice of law, simply put, is to apply the law to a set of facts. This means, of course, that the fact pattern is extremely important. And you'll find that we're dealing with people who are involved in law, that they're quite interested in the fact pattern. In fact, the fact pattern is all important to how the law is applied. One little change in the fact pattern can change the way the law applies. And a lot of people don't understand that, but it's quite important. So let us go now to the definition of the practice of law. This comes from this book right here, which is Black's Law Dictionary. And I have it on the screen, so later on I'm going to refer back to it again. But I'm taking some of this stuff from Black's Law Dictionary, which is a publication of West Publishing Company. Okay, the practice of law. This is the definition given in Black's. The rendition of services requiring the knowledge and the application of legal principles and technique to serve the interest of another with his consent. It is not limited to appearing in court or advising and performing of services in the conduct of the various shapes of litigation, but embraces the preparation of pleadings and other papers incident to actions and special proceedings, and in the larger sense includes legal advice and counsel and preparation of legal instruments by which legal rights and obligations are established. A person engages in the practice of law by maintaining an office where he or she, of course, is held out to be an attorney using letterhead describing himself or herself as an attorney, counseling clients in legal matters, negotiating with opposing counsel about pending litigation, and fixing and collecting fees for services rendered by his associate. This comes again from Black's Law Dictionary. I have the 6th edition here, which is an older edition, by West Publishing Company, coming out of St. Paul, Minnesota. Mine is from 1990 at page 1172. Now I want to tell you that that I've already looked into getting the latest Black's Law Dictionary. I believe it's the 10th edition, which is out now. And as everything else that you probably know, the price goes up. I'm going to get one, but like I said, the price has gone up, and legal books are not particularly cheap. So I will be getting one of those, however. Okay, let us continue. Let me clarify here. This is what I wrote in my notes. You don't know the law on any particular subject until you know the exceptions to that law. This is a rule that you need to remember. So when you're talking about law, it's one thing to know what the law says, but you need to know the exceptions to that law, because there very often are exceptions. Thus, not only do we have Johnson versus Avery to rely upon, I'm going to talk about Johnson versus Avery as we go along. As to legal advice, you may render your opinion. This is what I would do. So in other words, you say, well, let's say you're a non-lawyer and you're talking to somebody, and the bar and the Association of Attorneys says, well, you can't give people legal advice. Well, this is true. You're not supposed to give people legal advice in an official, legal, professional capacity. However, you are able to render your opinion and say, this is what I would do if I was in the situation you're in. And you can do that, rendering your opinion like that. As to the law or legal subject, you can do that all day long. So just remember that when you're talking to somebody about law and you happen to know a little something about it, then you can say, well, you don't say, I'm a legal professional and I'm giving you my official legal advice. Don't do that. What you need to do is say, well, this is my opinion of what I would do if I were in your situation. You can do that and you'll be perfectly safe. Okay. Just do not hold yourself out as being an attorney and a member of the bar. Moreover, you may, as a non-lawyer, teach other non-lawyers on the subject of law without being an actual practitioner of the law. The key to keeping yourself out of the crosshairs of the Bar Association and the district attorney, the reason I say district attorney is because there are laws which say that you cannot practice law like an attorney. Here in Oregon, I believe the statute is, I'm doing this from memory, I think it's 9.160. Here in Oregon, if it hasn't changed, I don't think it has changed. The issue hasn't come up for many years, but that's what it was, is 9.160, and I think it still is. That's the statute here in the Oregon Revised Statutes, is to make sure that those you discuss legal matters with are making legal decisions for themselves, and that you are not making such legal decisions or determinations for them. So you can tell them what your opinion is. You can tell them what you would do if you were in that situation, but you always leave it up to them to make these legal decisions for themselves and make sure you're not making the decisions for them. Again, you'll be perfectly all right if you do that. That, of course, includes being sure that they read the laws at issue for themselves, and then to let them brainstorm how that may affect and apply to their particular legal situation. Okay, let me explain a little bit more about that. Okay, let's say that you have taken the trouble to read a statute in the state statutes. And then you say, well, I read that statute, I understand it makes perfect sense to me. Then you go to your next friend and you say, well, I read the statute and here's what it means. Well, you got to be careful about that. You can say, I read the statute and here's what I think it means. Here's my opinion of what I think it means. Perfectly safe. What I would recommend is that you have them read the statute for themselves. You can have a copy of it with you, no problem there. Have them read the statute for themselves and say, here's what I thought it meant. Now that you have read it for yourself, what do you think it means? There again, you're not making a legal determination for them. You're telling them to read it, and you can then discuss. We both read it. What do we think it means? And you can say, well, I think it means this. And the guy says, yeah, I agree with you. I think it means that. Well, that's them making a legal determination for themselves about what a statute means. When you start interpreting statutes for them and they never read anything, you're starting to tread into ground that the Bar Association and the district attorney might find objectionable. Okay, well, We'll get into more of that later. Just because the Bar Association and the district attorney may find it objectionable doesn't mean you're in trouble. It just means that the Bar Association thinks you're treading upon their legal turf, and the district attorney says, well, there's a statute there that I think I might be able to apply to you, like ORS, Oregon Revised Statute, like we'll call them the ORS here, 9.16. Oh, you might be in violation of that, and I might have to do something about it. But you have to be able to negotiate your way through these things, and that's what I'm here to help you do. All right. As is usually my procedure, we're going to do something else here. We're going to talk about what does the Bible have to say. And you'll notice I do that a lot when I start talking about issues. I'll say, well, what does the Bible have to say? I did that when we were doing the covering the subject matter of abortion, for instance. And then I went ahead and explained what some of the verses in the Bible had to say about it. Well, we're going to do some of that here now. I think it's important. And we're going to go to the book of Luke, chapter 11, verses 39, 43, 44, 45, 46, and 52, and see just exactly what do those verses state. Now, I put it here on the board so I don't actually have to hold the Bible. My Bible's right here. This is actually my second Bible. I wore the first one out. It kind of fell apart. And so that gives you kind of idea how much I was into that one. It's really sad for me that the Bible fell apart like that, because it was given to me by my father, Pastor Michael Benjamin Sr., and I'm going to try and get it repaired because it's kind of got sentimental value for me to it. Okay, let's go to verse 39 and see what it says here. And the Lord said unto him, Now do ye Pharisees make clean the outside of the cup and the platter, but your inward part is full of ravening and wickedness. Now the Pharisees were, in about 2,000 years ago, these Pharisees were kind of like legalists. And they weren't attorneys per se, but they were legalistic in their approach to issues. Okay, let's go to verse 43, which says, Woe unto you, Pharisees, for ye love the uppermost seats of the synagogues. So they like to be in high places, and tell people what things meant. Then in verse 44 it says, Woe unto you, scribes and Pharisees, hypocrites. This is the Savior calling them hypocrites. And now that we have to add, it's not just Pharisees, now it's the scribes. Well, you might ask yourself, well, what is a scribe? A scribe is a person who was an official who took down dictation of what people said and wrote it down, so to make a record. It's kind of like a person who makes an official record of things that were said. For ye are as graves upon which appear not, and the men that walk over them are not aware of them. Okay, well, let me explain a little bit about what those verses kind of are saying. The common thread in these verses is that these people, like Pharisees, which are authoritative legalists, and scribes, which are authoritative record keepers who jot down every word and utterance, strayed from doing their jobs in righteousness. One of the key aspects of the problem was to withhold from the common people necessary knowledge, and thereby gain power over those who did not know enough, having to rely upon others to tell them what important things meant. So here's where you start running into problems with people who know things that you don't know, and they gain power over people that don't know by knowing things that you don't know and that you maybe are ill-equipped to know. Okay. Immediately thereafter, there were people who were listening to the Savior saying these things. And in verse 45 of chapter 11 of Luke, it says this, Then answered one of the lawyers, and said unto him, Master, thus say thou, meaning having said that, reproachest us also, meaning do you think that we are of the same as the scribes and Pharisees? Then in verse 46, this is a key verse, then the Savior said this. He said, Woe unto you also, ye lawyers, for ye laid men with burdens grievous to be borne, and ye yourself touch not the burdens with one of your fingers. Then we move down to verse 52 of chapter 11, where it says, this is the second verse which directly addresses the lawyers. It says, Woe unto you, lawyers, for you have taken away the key of knowledge. Ye entered not in yourselves, and them that were entering in ye hindered. Okay, I have a little explanation following this of those two verses. So in the first verse, this is verse 46, it says that the lawyers are laying burdens upon people, grievous to be borne, and they touch not those burdens with one of their fingers. And then in verse 52 it says, Woe unto you, lawyers, ye have taken away the key of knowledge. Ye entered in not yourselves, and them that were entering in ye hindered, meaning more or less that when people tried to get knowledge without having you in the picture, then you hindered the people from getting this key of knowledge that they needed. This is important. This is really, really important because, especially verse 52, because this key of knowledge that they have taken away, supposedly back in the time of Luke when this was written, you have taken away this key of knowledge, and they seem to have an interest in not having you gain this key of knowledge, so they hinder you when you try to get the knowledge. This is exactly what we're dealing with now today, that the people do not have the knowledge to know what things mean and what things are and how to negotiate their way, for example, to their inherent rights. And as we know from Hosea 4:6, it says, My people are destroyed for lack of knowledge. Remember as we go along that that's what I'm doing here, is I'm giving you back the key of knowledge that you have lost, and that it says here the lawyers have taken it away. I'm not making any value judgments. I'm just reading from the scripture. It says you have taken away the key of knowledge. And when the Savior says something like that, and this is the Savior talking, I have no reason to believe that he doesn't know what he's talking about. Okay, now here's what I wrote after that. Okay, before we condemn all lawyers, we ourselves must strive to be just and righteous. The reason I wrote that is because it's no good for us to say, oh, I hate all lawyers because here's Pastor Mike telling us they took away the key of knowledge and they don't touch the burdens themselves. They just let us bear the burdens. And, pretty soon people get angry at the lawyers and maybe get some hateful feelings, and they say, well, I just want to be against lawyers. I just want to put them in their place. And if next lawyer I see, I'm going to call him dirty names and all that. That's not what we do. That's not what we do. That's why I said here, we ourselves must strive to be just and righteous. The truth is, not all lawyers are functioning dishonorably. Obviously, some do. First of all, many, many lawyers are asked to handle an unrealistic caseload and still do a good job. And this is really problematic. If you knew some of the caseloads that some of these lawyers have to handle, it's just not realistic to think that they can devote the kind of time and concern for your little case when they've got like 100 other cases to handle. Because it can't be done, I can tell you. I've handled as much as 8 to 10 cases at once, and I can tell you that was a burden, and that's nothing compared to what an average lawyer handles. That's nothing. Okay? Also, I'd like to tell you that lawyers have been handed a case file because of some mix-up. The regular attorney was going to handle the case in court, couldn't be there, so they had to take over for another attorney, and the next thing you know, you've got an attorney being handed a case file that they've never seen before, representing or trying to represent a client that they've never seen before or talked to, and gone into court and said, now you handle it. Well, that's tough to do, that's really tough to do. And some lawyers are actually asked to do exactly that. No person can do a really good job when handling a performance-crippling caseload. Let us be fair and let us be just and righteous about what we're asking lawyers to handle and do. And then we says, well, we want you to move mountains when you've got like 50 other mountains to move. Well, that's just not reasonable. Okay. Moreover, lawyers are often under numerous pressures to operate within the legal sandbox by all the sandbox rules they didn't create and have to try to survive in that environment. Okay. Finally, just like other professions, like, for example, law enforcement officers, who can be called behind closed doors and threatened with loss of badge and gun, lawyers operate under the constant sword of disbarment for straying outside the legal professional's boundaries, or what some other people like the Bar Association and other powerful people in the legal profession have decided is the rules. Okay, I'm not making excuses for blatant excursions outside of righteousness and justice, as well as respect for inherent rights. I'm just pointing out what the lawyers are up against. Thus, we must at least be somewhat understanding when it comes to lawyers in the matter of pre-existing and inherent rights hesitating to venture outside of constitutional limits and boundaries, which they are sworn to uphold. You see, they are sworn, they take an oath, and like a lot of other public officials, they're sworn to uphold the Constitution, which means that their way to remedies and solutions and legal determinations is through the conduit of the Constitution. Okay, so when you're asking them to go outside the Constitution to push your God-given inalienable rights, they may have some problems doing that. All right. It is somewhat contradictory, however, for our public servants to venture outside of those same constitutional boundaries to pursue modern agendas, which appear to be fair game, but are outside of their constitutional oath. So you can't have it both ways. You can't say, well, I can't help you with your inherent rights, because that would make me go outside of the constitutional conduit. But when we have an agenda, we're going to go ahead and go outside the constitutional conduit, and that's okay. That's fair game. Well, I got a problem with that, and I think you probably will have a problem with it too if you really think about it. As always, I'm going to tell you, watch this tape once, watch this recording once, set it aside for a little bit, come back and watch it again, maybe 2 more times, and you'll get more out of it each time. Okay, we're going to move on now to counsel cases. Before I get into that and read from the counsel cases book, this is the counsel cases book that I have. I haven't looked at it for years and years and years, but because I was going to do this tape, I dug it out of mothballs so that we could address it in this session. One of the statements, this is from the case of Johnson versus Avery, and Avery was the commissioner of corrections, and Johnson was, of course, an inmate in a prison. Okay, this is cited as 393 U.S. 483. This is a 1969 case. Now, at 393 U.S. page 498, the way these sites go, it's like 393 is the volume, and the second number that's put out, 483, is the page number. But we're going to go to volume 393 U.S., means it's a U.S. case, U.S. Supreme Court case, page 498. Here's what it says at page 498. This is Justice Douglas, by the way. The preparation of legal petitions must never be considered to be the exclusive prerogative of the lawyer. Laymen in and out of prison should be allowed to act as next friend to any person in the preparation of any paper or document or claim, so long as he does not hold himself out as practicing law or as being a member of the bar. The cooperation of and the help of laymen as well as of lawyers is necessary if the right of reasonable access to the courts is to be available to the indigents among us. For those who don't know what indigent means, it means people who can't afford lawyers. You're too poor to afford a lawyer. Reasonable access to the courts is a right secured by the Constitution and laws of the United States, being guaranteed as against state action by the Due Process Clause of the 14th Amendment. Okay, let me, before we go to the counsel cases book, let me back up a little bit and see here. Remember when we were talking about what the practice of law was? Okay, we said, you got to be careful with the Bar Association, for example, because they kind of got a stranglehold on the practice of law. I mean, if they could get away with it, they'd probably tell you that if you told somebody where the courthouse was, you were practicing law. I mean, we got to be reasonable at some of this. And by and large, the state statutes which prohibit and limit the practice of law to legal professionals is either written directly or endorsed by the Bar Association. They want to protect their legal turf. Well, remember when we said when we were reading from what the practice of law was from Black's Law Dictionary, then they said, well, if you prepare any legal document that has any legal effect whatsoever, you're practicing law. And of course, that's, according to them, that's unlawful. However, in Johnson versus Avery back in 1969, I was alive when this judgment came down. They had a little bit of different view about it. Johnson versus Avery is what's normally called the jailhouse lawyer case. Okay, and they said that you should be allowed to go to your next friend and have him help you in the preparation of a paper or document, so long as you don't hold yourself out as practicing law or being a member of the bar. Then it goes on to say, the cooperation and help of laymen as well as lawyers is necessary if the right of reasonable access to the courts is to be available to the indigents, means the poor people who can't afford lawyers among us. Reasonable access to the courts is a right. You see, you shouldn't be barred from the court because you can't afford to pay the fee, or because you can't afford to hire an attorney, or whatever, because that is just shutting a whole section of society out from justice. And that is abhorrent and repugnant to our way of jurisprudence here in the United States. Okay, let's go ahead here and read from counsel cases. I have it marked off with sticky notes here, makes it easier for me. All right, let's dig into Johnson versus Avery. This is a landmark case. Johnson, who was, of course, an inmate, like I said, and Avery was a commissioner of corrections. This is a certiorari to the United States Court of Appeals for the 6th District. This is federal court, of course. Argued November 14th, 1968, decided February 24th, 1969. Petitioner, a Tennessee prisoner, was disciplined for violating a prison regulation which prohibited inmates from assisting other prisoners in the preparation of writs. The district court held the regulation void because it had the effect of barring illiterate prisoners from access to federal habeas corpus and conflicted with 28 U.S.C. Section 2242. The Court of Appeals reversed. This is the Federal Court of Appeals for the Sixth Circuit, finding that the state's interest in preserving prisoner discipline and limiting this practice of law to attorneys justified any burden the regulation might place on access to federal habeas corpus. Held, this is the final holding. So what you got is the district court, which is the federal trial court, said, okay, yeah, we recognize that, the state has to let you guys go ahead and help each other because you have to have reasonable access to the court. The Federal Court of Appeals for the Sixth Circuit says, no, we don't agree with that. We're going to reverse. We're going to say that the state interest overrides the needs of the prisoner because they have to preserve discipline and limit the practice of law to attorneys, just like it says here, justified any burden that might be placed on access to federal habeas corpus. Now here's the Supreme Court. It was taken to the Supreme Court, and the Supreme Court said in that case, in the absence of some provision by the state of Tennessee for a reasonable alternative to assist illiterate or poorly educated inmates in preparing petitions for post-conviction relief, the state may not validly enforce a regulation which absolutely bars inmates from furnishing such assistance to other prisoners. So it started out in the favor of the prisoners, then it flip-flopped against them in favor of the state, then at the Supreme Court level, flip-flopped back in favor of the prisoners. Let's go on. Okay, here it says that application for a writ of habeas corpus shall be in writing, signed and verified by the person for whose relief it is intended or by someone acting in his behalf. Okay, so that means that, of course, a person can pursue a writ of habeas corpus acting on a prisoner's behalf. I've in my time, I've done several of these habeas corpus myself, so I kind of have some experience and knowledge of it.
You should give just a quick of what habeas corpus is.
Yeah, we're going to get to that. I got that. Let me see in my notes here. We got that, yeah. Yes, we're going to come back to that. I actually got Black's Law Dictionary. Turn to the page for habeas corpus. Just remind me if I forget to do it. Okay, this court has constantly emphasized the fundamental importance of the writ of habeas corpus in our constitutional scheme, and the Congress has demonstrated its solicitude for the vigor of the great writ. The court has steadfastly insisted that there is no higher duty than to maintain it unimpaired. This comes from Bowen versus Johnson, 306 U.S. 19 and 26. It's a 1939 case. Then we'll read down further. I'm skipping, of course, because I can't read the whole thing on Johnson versus Avery. It'd take too long. For example, the court has held that a state may not validly make the writ available only to prisoners who could pay the $4 filing fee. This is from Smith versus Bennett, 365 U.S. 708, 1961. Well, back then it was a $4 filing fee. You can bet it's not $4 anymore. Now let's go on to read some of these. See if we've got some parts of this thing highlighted for you. For instance, the state is obligated to furnish prisoners not otherwise able to obtain it, by it they mean the writ of habeas corpus, with a transcript or equivalent recordation of prior habeas corpus hearings for the use in further proceedings. This is Long versus District Court, 385 U.S. 192, 1966. Now skip down again, but this court held that the regulation violated the principle that the state and its officers may not abridge or impair petitioner's right to apply to a federal court for a writ of habeas corpus. 312 U.S. at page 549. Cochran versus Kansas is cited as 316 U.S. 255, 1942. The district court concluded that, for all practical purposes, if such prisoners cannot have the assistance of a jailhouse lawyer, this is kind of where the term jailhouse lawyer came from, their possibly valid constitutional claims would never be heard in any court. This is 252 Federal Supplement at page 784. And the case site here is, I'm not sure what the case site is. It just gives the federal supplement. You'll get it if you type in 252 federal supplement at page 784. They'll come back with the stuff for you online. Okay, so they're saying here, basically what they're saying here is that if people did not have the ability to go to their next friend, jailhouse lawyer or not jailhouse lawyer, to get some help with these habeas corpus legal pleadings and documentation and file them in court, they wouldn't have any option to even have it heard in any court, because the system just wasn't set up so that you could do that. All right, let's move on as we go here. This is a continuation of Johnson versus Avery. In reversing the district court, the Court of Appeals relied on the power of the state to restrict the practice of law to licensed attorneys as a source of authority for prison regulation. The power of the states to control the practice of law cannot be exercised so as to abrogate federally protected rights. This is in the case of the NAACP versus Button, 371 U.S. 415, 1963. They cite an additional case here, Sperry versus Florida, 373 U.S. 379, also in 1963. In any event, the type of activity involved here, preparation of petitions for post-conviction relief, though historically and traditionally one which may benefit from the services of a trained and dedicated lawyer, is a function often, perhaps generally, performed by the layman. Often these writs are performed by laymen, especially when people are incarcerated. Title 28 USC, USC means United States Code, Section 2242 apparently contemplates that in many situations petition for federal habeas corpus relief will be prepared by laymen. Now we go on to Mr. Justice Douglas concurring with the majority opinion of the court. And it says here with one of the writings of Justice Douglas, we think of claims as grist for the mill of the lawyers, but it is becoming abundantly clear that more and more of the effort in ferreting out the basis of claims and the agencies responsible for them, and in preparing the almost endless paperwork for their prosecution, is the work of laymen. There are not enough lawyers to manage and supervise all of these affairs. Now, I don't, that was back in 1969. I couldn't tell you exactly how many lawyers there are now, and maybe there are enough lawyers, but it makes little difference. The issue here is whether you can have your next friend help you with legal pleadings. That's the issue. And Johnson versus Avery says that you can. Okay. Let's move on. There are not enough lawyers. Okay, I read that already. Let's see. And much of the basic work done requires no special legal talent. This is what Justice Douglas says. He says this requires no special legal talent to help someone with a writ of habeas corpus. All right. Yet there is a closed shop philosophy in the legal profession that cuts down drastically active roles for laymen. Well, I'll talk about that in a minute, but it was expressed by a New York court in denying an application from the Neighborhood Legal Services for permission to offer a broad legal aid type of service to indigents. A lot of people just simply cannot afford to go to a lawyer and have a lawyer do some of these things for you. So what the court is basically saying is that the help of these laymen in helping you get, for instance, a writ of habeas corpus, is necessary for justice and the protection of our basic rights. Let me say that again. It is necessary for justice and the protection of basic rights. Now, you may wonder, you may say, well, why is Pastor Mike spending all this time on Johnson versus Avery telling us how non-lawyers can help regular people? Well, the reason is, and I'll get to that, I'm moving on to that, the reason is that attorneys, for reasons that I will explain, may be unable or unwilling or both to help you with going outside the conduit of the Constitution to get to your inalienable, pre-existing, and inherent rights. And if they will not do that, and they might have good reasons for not being able to do it, and I'm going to get into that as well, if they cannot do that, you will have to rely either upon yourself to get it done, or you're going to have to rely on your next friend, quote unquote, to help you do that, you see. Now, it's extremely important that we understand that. Let me explain for a minute. I'm deviating now from the notes, and I'm deviating from the written material I'm reading from. Let me explain that if you cannot go to a lawyer to get this done, and if you want those inherent rights pursued, you don't have any choice but to do that yourself. And therefore, when you opt and say, okay, Mike Benjamin's, Pastor Mike over there, he explained some stuff to it, and I'm starting to understand now, and here's what I want to do. I want to take this whole kit and caboodle that Pastor Mike has shown me, run right off to a lawyer I know with my wallet in hand, and say, here's what it is. Here's what Pastor Mike said. He seems to know something about law, and here's what he said. Can you help me? Well, I know that you might be tempted to do exactly that, and I'm telling you right now that that's probably the wrong thing to do. As a matter of fact, I don't even recommend it for various reasons that I'm going to get into. Not only is it going to cost you more money to do that, but lawyers are going to have a problem with filing papers, litigating, and getting adjudicated your right to have God as your sovereign, which of course is one of your inherent rights. And then there's a whole bunch of other inherent rights that you want to do. See, we are kind of conditioned that whenever we have a legal hiccup in our lives, the first thing we do is open up the phone book and say, let's see, where's a lawyer I can go to? Yeah, he's going to charge me a bunch of money, but shoot, I don't know how to do this, so let me get a lawyer to help me get my inherent rights. You're going to have a problem with that. You're going to have a problem with that. You're going to say, oh, Master Mike, you're just saying that so we'll all have to come to you. And we'll all have to, and then finally you're going to, you never asked us for any money so far, but finally you're going to say, just throw your wallet in and forget it, One mechanic said that to one of my sons. He says, well, I got a problem with my car, and he took it to his shop, and he says, just throw your wallet in my shop, and I'll take care of it, Well, I can assure you that's not what I'm trying to do here. It's not what I'm trying to do here. I'm simply telling you, you go to a regular attorney of the bar, and there are some very good reasons, which I'll get into, why he can't help you. Why he can't help you. You know who's doing that all over the place? The people who are these 2A people. By 2A, I mean Second Amendment people. They say, there's people trying to take our rights of self-protection and our right to keep and bear arms away. And Pastor Mike said that it's not a constitutional right, that it's an inherent right of self-protection and the right to keep and bear arms. So I'm going to run right to an attorney and say, we got a bunch of people with their wallets out, want you to help us preserve our right to keep and bear arms. Well, if you want them to go outside of the conduit of the Constitution, you're going to have problems, because it's risky for them to do that. Not only is it unpopular in the legal profession, they could actually end up in disbarment territory for venturing outside of the conduit of the Constitution, which they are sworn to uphold. So, you may have to watch this tape a couple times to get what I'm saying. All right. let's move on. We're not done with Johnson versus Avery. As you can see, I'm turning a lot of pages. There's a lot to Johnson versus Avery. All right, let's see what else Justice Douglas had to say. The difficulty with an ad hoc program resting on a shifting law school population is that, worthy though it may be, it often cannot meet the daily prison demands. In desperation, at least one state has allowed a selected inmate to act as jailhouse counsel for the remaining inmates. See, this back then had become a common thing. They said, there's just nowhere for these prisoners to go. They don't have the money, or they don't. There are many reasons why they can't get help. The attorneys were overworked, and the last, just think of it from an attorney's point of view. An attorney can go help people who are not in prison and help them get their cases adjudicated and litigated and help them get their rights. And the last person on their list is like inmates already in prison, who we all assume are, well, I don't assume that, but a lot of people assume if you're in prison, you're guilty and you're getting your punishment, and you're the last person we want to help. You're the last person we want to help. We don't care that much. You see, well, for a lot of reasons, that's not the right way to look at it. There are innocent people in prison who shouldn't be there, but for writs of habeus corpus and other legal remedies, they would be in real trouble. Fortunately, there are good lawyers out there who will help these people. Many of them will do it pro bono, which means for no money. Okay, let's keep going. This is still Justice Douglas concurring. It is not unusual, then, in the subculture created by the criminal law, wherein prisoners exist as creatures of the law, that they should use the law to try to reclaim their previously enjoyed status in society. The upheavals occurring in the American social structure are reflected within the prison environment. Prisoners having real or imagined grievances cannot demonstrate in protest against them. The right peaceably to assemble is denied to them. The only avenue open to these prisoners is taking their case to court. Prison writ writers would compare themselves to dissenters outside of prison. Some of these issues are absolutely the only thing that these prisoners have. All right, let me reread. This is Justice Douglas again. I'm going to end my little excursion into Johnson versus Avery by rereading this next part of Johnson versus Avery, which I read when I started, and I will reread now again. I actually had this quote on my wall for years and years. That's how important I thought it was. This again is Johnson versus Avery, 393 U.S. at page 498. The preparation of legal petitions must never be considered the exclusive prerogative of the lawyer. Laymen in and out of prison, now this little statement here, in and out of prison. These are not rights just for people in prison. These are rights for people out of prison, and Justice Douglas made that clear when he said in or out of prison. Should be allowed to act as next friend to any person in the preparation of any paper or document or claim. That's important. Any paper or document or claim, so long as he does not hold himself out as practicing law or being a member of the bar. The cooperation and help of laymen as well as lawyers is necessary if the right of reasonable access to the courts is to be available to the indigents, meaning poor people who can't afford a lawyer among us. Reasonable access to the courts is a right secured by the Constitution and laws of the United States, being guaranteed as against state action by the Due Process Clause of the 14th Amendment. Okay, I'm going to stop right there with Johnson versus Avery. I'm going to break from usual procedure, because we're kind of loosen things up a little bit, and ask my cameraman if he has anything to add or has any questions about anything I said so far.
Explanation of habeas corpus.
Okay, you want to move to the explanation of habeas corpus. Yeah, let's do that. I actually have that on my notes. Let me see what my notes reflect on that. Let's see. Yeah, let me go ahead and do habeas corpus. I think I had that listed in my notes in a different spot, but we'll get into it now. It doesn't matter. So let me put counsel cases away. Let's go to Black's Law Dictionary, writ of habeas corpus. Habeas corpus, this is at page 709 of the same Black's Law Dictionary 6th edition that I talked about earlier. We used to make jokes when I was first studying this, and we used to call it, this habeas corpus is a counter for what we called habeas grabus. And we called it habeas grabus is because that's when the officials grab you off the street, take you away, and people don't see you again, you see. Well, this goes back to the time when people were grabbed up by the king's enforcement agents and official personnel. People were grabbed up, thrown into a dungeon, and were never seen or heard of again, you see. And that's when it came, well, later on when it came to the great charter called the Magna Carta, they made sure that this writ of habeas corpus was preserved, because they said, look, we got to have a remedy for this. The king going around grabbing up people, tossing them into a dungeon. They don't even tell us that they're in the dungeon. That we don't even know what happened. For all we know, they were kidnapped by who knows who, and the next thing you know, the person just rots away in a dungeon, in the king's dungeon. You see, this is what caused some of this to come about, and the great writ of habeas corpus is a counter for that. Now let's read about habeas corpus. In Latin, it means you have the body. The name given to a variety of writs, of which these were anciently the emphatic words, having for their object to bring a party before the court. You see, what's happening there is the writ of habeas corpus. Corpus means body. Habeas is bring forth the body. To just bring forth the body wherever he is. If he's in the dungeon, bring him out of the dungeon, bring him into court, and we want to see whether he's being, what is the grounds upon which this person is being deprived of their liberty, and what is the justification of the king. And in this case, it's not about the king anymore. It's now about the government. What is the justification for having this person incarcerated and locked away like that? Okay. The primary function of the writ is to release from unlawful imprisonment. I read that already. The office of the writ is not to determine a prisoner's guilt or innocence, and the only issue which it presents is whether the prisoner is restrained of his liberty by due process. That's what it says here in Black's Law Dictionary. I have some of my own thoughts about that. I won't get into them. A form of collateral attack, an independent proceeding instituted to determine whether the defendant is being unlawfully deprived of his or her liberty. It is not an appropriate proceeding for an appeal-like review of discretionary decisions of the lower court. Initially, the writ only permitted a prisoner to challenge a state conviction on constitutional grounds that related to the jurisdiction of the state court, but the scope of the inquiry has gradually expanded. Let's see, there's more to it than this. Concluding that the writ now extends to all constitutional challenges. So in our time, the writ of habeas corpus means bring forth the body, bring him into court. We're going to review whether you're lawfully holding them. And also now you can use it as a post-conviction relief instrument and remedy to decide whether or not they're being constitutionally held. And so, you have to differentiate it from an appeal, a regular appeal, which works differently. Habeus corpus is a post-conviction relief remedy, not an appellate remedy. Okay, is that clear enough, or do you think we need to address that some more? You think that's enough? Okay.
I do have another.
You got another question?
Yeah.
All right.
For somebody who doesn't know, they might think that the statement that the courts made in Johnson versus Avery is in direct contradiction to the Black's Law Dictionary. Perhaps you could explain to them what that's about.
Direct contradiction in
Yeah.
what way?
Well, because as you pointed out in the Black's Law Dictionary, they're saying if you tell somebody the direction of the courthouse, that's practicing law. However, in Johnson versus Avery,
Yes,
they're saying
yes,
no. So,
yes. Well, of course, in Johnson versus Avery, they're addressing the issue of what the rights of people are. In the, let's face it, Black's Law Dictionary is written by lawyers, and just about all the lawyers are member of the bar. And the bar has an interest in keeping the practice of law and the practice of anything they say is the practice of law within their turf. You see, it's like a person saying, let me think of a good example. Let's say you have an association of carpenters, and then it is in their interest to keep customers coming to them for carpentry work. So will they be in a big hurry to have people do their own carpentry for themselves? Well, not particularly. Maybe there are some that say, oh, we don't care, just let the person do his own carpentry, we don't care. Well, the law is a little bit more jealous of their territory than possibly the carpenters are, but it would be the same thing. If the carpenters could go to the state, for example, and say only the people who are licensed and bonded carpenters of this Carpenters Association shall be allowed to do carpentry. And you can't even go to let's say you have a best friend down the street and he's building a little shed behind his house, and he says, can you come over and help me with building this little shed? And you're his friend. He says, sure, I'll come over a Saturday or Sunday and we'll do this over the weekend. Well, if the Carpenters Association could say, you can't do that. You see, maybe you can build a shed for yourself in your own backyard, but you can't go help your friend build his shed, because if you do, then you're practicing carpentry without a license. You see, I don't know if you are catching all this out there, people who watch this, but that's kind of like what the lawyers are doing. And you will find out as you go along, I've been through this many, many times, you'll find out that they will always try to say, the Bar Association and the attorneys, it's like, well, it's about protecting the public. It's about competence, you see. It's about competence. So if we're talking about carpentry, for example, and say, well, we want to make sure that this person knows how to build a shed. Otherwise you're going to go out to the shed to get a piece of wood and the shed fall in on you, and there you are up at the hospital. The shed fell in on you because he's not competent. So we're going to want to pass these laws on practicing carpentry without a license so that the shed doesn't fall in on you, you see. Well, those are all beautiful arguments, and I understand them. However, it isn't about competence. There are people out there who are not members of the bar, myself included, who are very competent. It isn't about competence, it's about control. And it's about protecting your turf. And it's about, let's face it, the practice of law is a lucrative profession. The last time I checked legal fees out, they were not cheap. They keep going up, just like everything else keeps going up. If it was just about competence, that would be one thing. It is not just about competence. So a person can be extremely competent, but they can't control them. How do you threaten a person who's not a member of the bar with disbarment? Well, the answer is, you can't. Well, then you go to the district attorney and say, prosecute him for practicing law without a license. He says, well, the district attorney might say, I knew the district attorney here for 33 years. He knew me and I knew him. The thing is, he knew I was competent, and they kind of pretty much left me alone. There's a reason why I'm not an attorney today. And the reason I'm not an attorney today is because I found out long time ago that an attorney of the bar can't pursue inherent and inalienable and God-given rights. I knew that a long time ago. They would just threaten you with disbarment and say, hey, you can't do this, and if you keep it up, we're going to disbar you. So why bother? Why bother with that? You see, I could have been a wonderful attorney. There's no question in my mind I could have been. In fact, that is where I was going. I was headed for exactly that. When my father took me aside and said, no, he says, you're going to go into the ministry. And I says, I don't want to go into the ministry. I want to go into the law. And he says, no, you're not going to be able to do that. You're going to go into the ministry. But the problem with that is that I loved the law. And so I studied law anyway. And I learned everything I could about the law. And, I'll just mention, my grandfather was a lawyer. But anyway, the point is, there was a reason why God had all this stuff happen the way it did. I didn't know it when I first started out. I didn't realize that an attorney of the bar could not pursue God-given inalienable rights. Couldn't even begin to argue the issue of the sovereignty of God. Could not even begin to argue it. Could not begin to go outside of the conduit of the Constitution and talk about rights that pre-exist the Constitution. Now, an attorney can technically do that, but they take great risk in doing it. So the reaction of the courts, the reaction of the bar, who knows what they would do to an attorney who tried to do that. And some of these attorneys got one heck of a lot to lose if they were to pursue a case like that and lose their very livelihood. And, the other thing is, too, I don't want to make too big a deal out of it, but the other thing is, too, a lot of these attorneys have big student loans to pay off. And they just simply can't afford for big problems within their legal career because they got student loans to pay off, which means that people have control over, how far they're willing to go outside of certain parameters. Have any other questions based on any of that? Okay, let's move on. Let's see, Johnson versus Avery, we got through that. Let me read what I wrote just after that. One can no more go through life not knowing at least some law than he or she can drive or travel upon a roadway without knowing how to fix a flat tire. To go through life with a minimal amount of legal survival knowledge is to condemn yourself to hobbling along on a flat legal tire for the rest of your life. Unless, of course, if you repair to the legal profession every time the slightest legal blip occurs on your life radar. You see, this is what I've been telling people for a very long time. Like I said, I've been in the court many times. I've written writs, I've written pleadings, I've done all kinds of stuff. I realize, if you say to me, Pastor Mike, there are people running around who are not lawyers, they're laymen, and they say, I know the law. And so I go to them hoping that they really do, because I can't afford a lawyer, and see if they can help me. And it turns out they don't know hardly anything, and they know just enough to get themselves and me into trouble. And you're right. You're absolutely right. There are lots of people like that around. Make no mistake, however, that there are people who are not members of the bar, who have studied law, like myself, and are not in that category. Because I can tell you right now, I have spent decades in this study. I've spent decades being involved in it, and I do know what I'm doing. And I don't fit into the paradigm of these people who run around saying they know the law and don't know anything. You see, I've actually used that in my advantage in the past when I did go to court, because people would assume that I was one of those guys. And I kind of ambushed him with my knowledge of law, and it worked in my favor. So sometimes I go through the exercise of making it look like I don't know anything, because that leaves big avenues open for strategy and ambush of my legal adversary. And maybe that's not all. Maybe say, well, oh, Pastor Mike, you do stuff like that? Well, I didn't create the sandbox. I'm expected to play in the sandbox at certain points by the sandbox rules. And so, I feel that without getting into areas where I'm really doing something wrong before the Lord, there's some room for me to operate. So that's what I would be telling you, because you may be wondering about what Pastor Mike is actually up to. And I'm going to leave it up to you to figure out for yourselves. Does Pastor Mike, he's not a member of the bar. He doesn't practice law in the regular sense. Does he know what I'm talking about? Well, I'm going to leave that up to you to figure out. I'm going to leave that up to you. Okay. Some attorneys are willing to circumvent the law in order to reach a desired result. The problem with that is, of course, that public officials are sworn to uphold and protect the U.S. Constitution, and we must hold them to that oath. Now, back in December, on December 12th, 2018, at 2:41 p.m., I wrote a little something about the oath of office in a post that I did. It was an uncoded post. And here's what I wrote. An oath of office is not just something you swear to as a formality to entering public office, which a person once in office may just dismiss or ignore to whatever degree they may choose. It is a binding oath that the people are fully justified in expecting will in fact be binding upon those entering and occupying public office. So it is with an oath to uphold the United States Constitution. Unfortunately, unconstitutional acts and omissions in varying degrees by those in power is not at all unusual. All right. Let me relay a little bit of a story about what happened to, I don't know if you know who Judge Napolitano is, but he's a well-known judge. He writes books. I have his books. And he said he went up to Washington there, and he was talking to some people in Congress that he knew. And they were talking about a piece of legislation that was being proposed in Congress. And Judge Napolitano told his friend who was part of the Congress, he said, you do know that the legislation that you guys are proposing is unconstitutional. You do know that, don't you, Judge? And you know what the guy told him? He says, Judge, you don't understand. He says, most of what we do up here in Congress is unconstitutional. So what does that tell you about the oath of office? That tells you, my son tells me that, he was telling me that I didn't understand. He says, look, these people don't take their oath of office seriously. This is just something they do. It's just a formality to taking public office. And once they get into public office, they jump right on the bandwagon and say, what's the next unconstitutional thing we're going to propose and try to get into law? Because we need to do that. Well, I got a problem with that. I don't know about you out there in America, in the people of the United States land, how you feel about your representatives in government taking an oath to uphold the Constitution and protect it, and then turn right around and pursue all kinds of unconstitutional legislation, which of course is going on all over the place out there. I could just go on and on and on about that. So, I think that we need to hold our public servants who take an oath to uphold the Constitution. I think we need to hold them to their constitutional oath, because it isn't just something, it's not just a formality, and it is something that our liberties and rights and freedoms are protected by. You see, now I'm not saying that all of our rights, liberties, and freedoms come from the Constitution, but they're mentioned in the Constitution as something that needs to be protected, and we need to hold them to their oath. It's not just like it says here. An oath of office is not just something you swear to as a formality to entering public office, which a person once in office may just dismiss or ignore to whatever degree they may choose. It is a binding oath that the people are fully justified in expecting will in fact be binding upon those entering and occupying public office. So it is with an oath to uphold the United States Constitution. And I think, I really don't need to say too much more about that. Let me go up and grab a book here. It's called Suicide Pact. It is a book by Judge Napolitano. I've got it right up here. Let me grab it down. This is the book, Judge Andrew P. Napolitano, called Suicide Pact. Okay? In this book, Suicide Pact, Judge Napolitano opposes the notion that adhering to the U.S. Constitution amounts to a suicide pact where we may perish in doing so. I oppose it as well, and say it is not so. The Constitution is the law of the land, and there are people all over the place who just want to circumvent it and say, man, if we obey the Constitution, why, we'll just all perish. Well, I don't believe that's true. Judge Napolitano doesn't appear to believe it's true. And I believe that the Constitution has got a whole lot of life still left in it. And I can tell you that there are those who are pushing the idea that the Constitution is horse and buggy law. And it's old, outdated law. 200 years ago, those backward and people who did not know what the future was going to be, their ideas of what was good for America are not important anymore to us, and we need to just get rid of the Constitution and shove it aside without them telling us exactly what's going to replace it, and have something new. Well, as I've said before, and I say again now, you don't talk about, first of all, it's not horse and buggy law. It is still valid and good law today. Second of all, you don't talk about getting rid of something like that without having a real solid foundation of what's going to replace it. The idea that it's not up to date anymore, it's outdated, it's not realistic anymore, it's a suicide pact. We're going to all perish if we don't do it. The Constitution is constantly hindering us from doing what we have to do. Well, and they say, what kind of things are causing us to have to do what you're saying, this suicide pact? Oh, well, that's classified. You don't have the clearance to know all that, but I tell you, it's dangerous. It's dangerous. Well, you're telling me stuff I can't know is cause for this being a suicide pact, and now you want to replace it, and you're not telling me what with. Well, my son here, he's the camera, he's already smiling and laughing, because that doesn't make any sense. Wake up, America, wake up, America. This is not the way to do business with the sovereign people who they work for. This is not the way to talk to the people who put you in that office. Okay, let me put this book away. It's not a suicide pact. All right, let's move on. Let's see what else I wrote here that people might find objectionable but true. Okay. Allowing in inadmissible evidence, of course, that's one of the things that comes from the Constitution. These are rules. Allowing in inadmissible evidence can occur because of a failure to object. Remember the rule that silence denotes agreement. Okay. Court situations have occurred where two opposing counsels were before the court, and the prosecution tried to get inadmissible evidence admitted. the judge looked to the defense counsel to object, and he did not do so. So you picture this, you've got two attorneys before the court. The judge is sitting up there at the judge's bench. You got a prosecution and defense. The prosecution is trying to get inadmissible evidence admitted against the client of the defense counsel, and the judge is looking at the defense counsel to object. And for one reason or another, the defense counsel does not object. If the defense counsel had sneezed or cleared his throat, the judge would have ruled sustained. He was that sure that this was inadmissible evidence, and that if only the defense counsel would object, he would have sustained it. But the defense counsel didn't do that. And so the inadmissible evidence was allowed in. That's how obvious the defect of evidence was, that the judge was just chomping at the bit to sustain an objection, but the objection never came. But because there was no objection, the inadmissible evidence got in. The exclusionary rule, which some want to remove and be gone from legal practice and procedure, claiming it hinders law enforcement, states, any evidence obtained in violation of a person's constitutional rights is inadmissible in a court of law. Okay, that is to keep, not only to keep inadmissible evidence out, but it's also to keep the police from having practices and procedures that aren't careful about what evidence does get admitted to the court. It has to be according to the law of the land. Otherwise, the exclusionary rule excludes the evidence. And a lot of people are saying, this is just burdensome, and it's letting criminals get away with crime, and just because of this technicality of the Constitution, that we think that inadmissible evidence should get in because it's easier for law enforcement, easier for us to put criminals away. Well, I don't know what to tell you. I don't want criminals on the street either. Sometimes criminals walk because the police didn't do their job right, and the evidence gets excluded because it was unconstitutionally obtained, and they tried to get it admitted into the court, and the court said, no, it's going to be excluded. It was not done according to the Constitution. The Constitution is there to protect not just people say, well, why are we letting criminals go on that basis? No, it isn't just to protect the criminals. It's to protect all of us from having unconstitutionally obtained evidence used against us. And that's, it's so important that it's better to let a few criminals go that fall into that inadmissible evidence category, and then they can't make their case. It's better to let some of them go than to subject all of society to the specter of being convicted with unconstitutional, inadmissible evidence. That's the real truth. And then you got people trying to do away with it, saying it's a hindrance to law enforcement. Well, I was a law enforcement officer. Let law enforcement officers do their jobs right according to the law. That's what I say. I went through classes when I was in law enforcement on constitutional limitations on law enforcement. I don't know exactly how much time they spend on that today, but they sure as heck spent some time on it when I was going to the police academy. And I've been through 3 police academies. If I were a judge, I would on my own motion, even if the defense attorney failed to object to inadmissible evidence, not let such unconstitutional evidence pass. Not on my watch. Not on my watch. For a judge to sit back and knowingly allow inadmissible evidence to enter in, which is unconstitutional, just because the counsel didn't object, that's not the way it should work. That's not the way it should work. The judge shouldn't just sit back and say, well, I guess the defense attorney didn't do what he was supposed to do. I guess that means that the unconstitutional evidence gets in, and that unconstitutional evidence may well convict a person. And I'm just going to let that pass because the defense attorney didn't do his job. Well, there may be judges around that want to do that. I can tell you right now that if I was a judge, that would not pass. Not on my watch. The law is an honorable profession, and many lawyers do what they can to stay within the boundaries of justice and righteousness, even going as far as handling cases pro bono, which means for free, sometimes for years. Okay? I have certainly met lawyers who are decent and concerned people and work in anguish very hard to get justice within the jurisprudence sandbox. However, they must play the legal game by the prevailing sandbox rules. Let me read that again. However, attorneys must play the legal game by the prevailing sandbox rules. They didn't make the rules, but they have to play by the rules. Nobody wants to mess up their future, and that includes attorneys and other people. Telling the real truth and wandering outside the sandbox rules can indeed do that. In other words, can mess up your future. Remember that an attorney's knowledge and advice is his or her stock and trade. Therefore, they are not generally encouraged or motivated to freely share what they know, even when their legal fees are paid. See, we are a country that puts you through grade school, puts you through high school, even puts you through 4 years of college, and you can come out of all that and not know the first thing about how to, even the littlest thing about how to protect yourself legally, a little bit of legal survival. You can go through all that education and not get that. And that's a problem. That's really a problem, And then you've got these attorneys who their knowledge and advice is their stock and trade. I understand that. They don't give it away for free. Sometimes they do pro bono cases, and they do help people with their legal problems. However, they aren't encouraged or motivated to freely share what they know and cut down on their legal business. And to a certain extent, I can't blame them. I blame society for not preparing the average person for the minimal amount of legal survival. I do blame them for that. I blame for society for not, there are people that I know who have come out of high school and never opened up another book after that. I mean, they just don't learn anything. The simplest thing, a simple traffic infraction traffic ticket, they have no idea really how to defend it. They go to court and they go off point and they don't know really the first thing about how to even defend themselves against that. They just pretty much hope that the judge will take pity on them and understand their attempts to tell their side of things, and hopefully the judge will take mercy on them and let them get off on it. Not to say that everybody that gets a traffic ticket ought to get off, but there's some that obviously should. But we don't prepare people for that. And we really need to have some minimal legal knowledge in order to have a little bit of legal survival. That's what I'm trying to help you with here. I'm trying to work on that for you. All right. Let's go on to inherent and inalienable rights that pre-exist the U.S. Constitution. Yeah.
Quick question.
Quick question. Okay.
I wrote a note here, but what you said there a minute ago about you blame society for their sort of ignorance of the law.
Mm-hmm.
But in other areas, you sort of indicate that there is an intentional effort to control citizens and keep them in a state of enslavement to a certain extent to limited legal remedies.
Yes.
So, where do you think the intentional effort and society?
What I mean by that, it isn't as bad as what it sounds like. What I mean is that people believe that, the ones that I've met anyway, people believe that the law is too complicated for them to understand, and sometimes it is quite complicated. But there are simple things about the law that people don't even try to know. You see, I'll give you an example. You got the kind of person that goes to an attorney and explains to the attorney, here's my legal problem, can you help me? And then the attorney says, well, yeah, I can help you. Let's see what I can do. And they don't ask another question after that. They don't say, I'm not interested in how you're going to help me. I'm not interested in what the issues are that you're going to help me with, or what are the legal strategies and the legal principles on which you're going to help me. I'm just going to pay you money. I'm just going to write you a check and you get me out of this, you see. And he says, you don't want to know anything about how I'm going to get you out of it? And no, I don't care about that. Just call me when you've gotten me out of it, you see. Well, I don't do that. I've never done that. I know people who don't do that. The same kind of people who sign legal papers without reading them. They just want what they want. They don't care how they get it. Is this where I signed on this line? And they just signed it and off they go and they hope it all works out okay. Well, you see, we've kind of been conditioned to believe that that's the way we deal with the law. We don't have to know anything about the law. We just have to hire people who do. I hope you understand that that's not the right way to go about it. You need to know a little something about at least the case that you go to your attorney with. You need to know a little bit about how it is that your case is going to be handled. I've talked to people who said, yeah, I got an attorney working on that. Well, what's he doing for you? He said, I don't know. That's what I pay him for to know. I don't know. I said, well, don't you want to even read the law that's being used against you? No, that's what I pay the attorney for. I don't want to know any of that. I just want to pay a guy to get me out of this. That's all I want. Well, that's exactly the attitude that's going to get you into trouble when you're going through life worrying about, because I can guarantee you, almost everybody at some time in their life has some kind of a legal hiccup in their lives. And you don't want to be in a situation where you don't even know or don't care how you got through this legal problem, you see. Some people panic because they're so clueless about the law. They don't have the first idea. They just panic and say, my golly, I just got to get me a lawyer. I don't care how he does it, but he's just got to get me out of this. Well, I'm here to tell you, you've got to go a little deeper into it than that. You can't stop at the side of the road, say my tire went flat, and start looking around and panicking, saying, where's somebody to change my tire? And in the meantime, I just sit out here in the boonies and I can't go anywhere. You see, because it just so happens that not only did my tire go flat and I don't know how to change it, but my spare tire isn't up to snuff either, so I can't put that on and go anywhere either. Don't be that clueless. Don't be that disconnected from your legal survival. You see, now you might say, well, boy, Pastor Mike sure asked a lot of me. Yeah, I do. I want you to open a book. I want you to watch Pastor Mike explain some of the law to you and not say, boy, this is boring. This is dry stuff, Pastor Mike. I could be doing something else fun. And I'm supposed to be watching you talk about Johnson versus Avery, for God's sake, I'm just not going to listen to that, inherent rights, I'm doing fine. The police aren't knocking my door down, at least not yet, so I'm not concerned. You don't get concerned when the avalanche is already covering up your house, you see. That's a little too late. All right, let's go on. All right, let's go on. Let's see what we got left here. Inherent and inalienable rights that pre-exist the U.S. Constitution. Pre-existing, inherent, natural, human, and God-given inalienable rights simply referred to as inherent rights in my teachings. It covers all that area, And I explained that before in some of my other recordings. Explain why a licensed attorney may not be able to go outside the U.S. Constitution. They are sworn upon oath to uphold the U.S. Constitution and the laws of the United States as applicable state constitution and laws as well. Therefore, it is very likely that you may have to represent yourself, or you may have to assert the inalienable right to have someone who can represent your issues, such as the sovereignty and jurisdiction of God for you. This is the focal point of all of this. These inalienable rights, your right of self-protection, your right to keep and bear arms, which is directly connected to your survival and your right to life, and your right to freedom, liberty, and rights, and your right to access to God as king and sovereign, you are going to be hard-pressed to get an attorney to step outside that constitutional conduit that they operate in and say, you know, I think I'm going to risk disbarment for you, and I'm going to go ahead and try to assert these things for you and hope that I don't get disbarred in the process and lose my whole legal career. Well, you know, good luck with that. That isn't going to work out for you too good. It's not about competence. I told you about is that it's about the legal profession being in control. Now, I have to make another tape about this other thing. I'll talk about it for just a second. Churches, most of your churches in the United States are corporations. Those are creations of the state under the Department of Commerce. Corporations, church corporations, must be represented by a state licensed bar attorney. Now, I don't know if you see a problem with that the way I do, but a church is supposed to be under the jurisdiction of God's kingship. Therefore, you have a jurisdictional problem there, you know. Now, the attorney who has to represent the church that's a corporation, which is a creation of the state, can only do so through the conduit of the Constitution and the First Amendment of the United States Constitution, which bars you from the sovereignty and kingship of God. So you explained to me, you've heard me talking now in my different various writings and treatises and videos that I've put out. How is an attorney of the bar going to help a church reestablish its right to exist under the sovereignty and jurisdiction and kingship of God when they are simply unable to do that? And then on top of that, you've got a church corporation which cannot assert those kinds of rights because of the doctrine of estoppel. You've taken on incorporation under your church. Now you go into church and say, I want access to the sovereignty of God because he's the king of the church. And then you say, well, yeah, but don't you have articles of incorporation that incorporate your church? Well, yes, Your Honor, I do. Are you licensed by the state to perform state civil marriages? Well, yes, I am, Your Honor. I said, oh. Well, that pretty much takes care of it, Pastor. If it's a pastor standing before him, it pretty much takes care of it. It means that we're going to adjudicate this case and litigate it based upon man's laws and based upon rules for corporate churches and based upon ministers who operate within that man's law paradigm. You really, without saying it, they're saying, don't come to me talking about God's sovereignty and jurisdiction and what your rights are under that jurisdictional paradigm when you're in here under a man's law paradigm with a corporate church and licensed pastors. And I'm only giving you the tip of the iceberg of the problem, just a tip. So you think about that as we move on. Okay. What about the thing that people say that self-representation makes you have, if you represent yourself, then you have a fool for a client. Let me talk about that a little bit. I've seen self-representation come out favorably many times. I've done self-representation myself that's come out favorably many times. So you can say, yes, that's what they've been telling us. I start to wonder about the motivation for the people who say that if you represent yourself, you have a fool for a client. Because I haven't seen that to bear out to be true all of the time. That's for sure, especially when a person represents themselves competently. So if you're so emotionally intertwined into the case that you can't step back from your emotionalism to represent yourself, well, that can be a problem. I get that. Okay, let me talk for a minute about Australia, in Sydney, to be exact. Many people are unable to hire an attorney, and around 50% of the people represent themselves, basically because they can't pay for an attorney. So this is by the admission of the Australian courts themselves in Sydney, saying that 50% of the people come in representing themselves because they simply can't afford to do anything else. As many as 87% of the people plead guilty and are then given light sentences or no penalties with a clean, and which of course says that if what they're telling you is plead guilty, we'll give you a light sentence and we'll fix it so that the penalty does not go on your record. Okay, well, there's something drastically wrong if you have to start off by pleading guilty. But anyway, that's what's going on in Australia. Lawyers often advise their clients in Australia to plead guilty because your chances of receiving a light sentence is much greater. I wonder about the 13% who do not plead guilty. What happens to them? Because if 87% plead guilty and hope for light sentences, what happens to the 13% that don't? I have to wonder about those people. What are their chances of getting a light or dismissed sentence with no blemish on their record? Well, I'll have to get back to you because I'm not sure what's going on there with that 13%. But if I find out, it might be interesting to talk about later. Just think about that, though. Remember also that telling the truth can mess up your future. I know, because that's what I'm in the business of. I run a Facebook truth ministry where I tell the truth all the time, and it has its negative side. Not before the Lord it doesn't, but it has its negative side in reality. I was a cop. I was a military policeman and a cop. And cops lie as part of their jobs. I don't know if you knew that, but they do. It happens all the time when working a case and questioning people to ferret out the truth and develop evidence. My own mother told me a long time ago, my mother told me, she said when I was younger, she said, "You're the worst liar I've ever seen." And she didn't mean that I lied all the time, making me the worst liar. She meant that when I did lie, I didn't do it very well. I got this horrible streak of honesty and integrity in me, which made me a bad liar. As Mr. Spock of Star Trek said, it is not a lie to withhold the truth. Okay? Therefore, using that same logic, many in and out of the legal profession rationalize that keeping the truth from you and letting you think that something untrue is the truth is not a problem. That has prevailed, for example, for decades as the legal profession allowed people to believe that their right of self-protection by the keeping and bearing of arms was a constitutional right, which was granted by the Constitution's Second Amendment, which of course we know is not true. I teach that it's not true. I'll tell you right now, I've written treatises on the right to keep and bear arms and self-protection, but we're going to make a video on it too, and that's coming. I don't know exactly when, but it is coming. Of course, that is not at all the case. No, the Second Amendment merely prevents the government from infringing an inherent right that you already had, Okay? So I won't go into that deeply now, but you know what I'm talking about. The people who've been listening to me, you know what I'm talking about. Judge Learned Hand on the Spirit of Liberty. I did it under that heading. This is under Code 2019A 268 here. It says, I think it was in 2018. That must be a typo. 268. What's the date here? Let me check it. There's no date, but I think it should have been 2018. Anyway, here's what Judge Learned Hand said. He said, liberty lies in the hearts of men and women, and when it dies there, no constitution, no law, no court can ever save it. Let me read that again. Liberty lies in the hearts of men and women, and when it dies there, no constitution, no law, and no court can ever save it. This is from a quote from judge and judicial philosopher Billings Learned Hand, born in New York on January 27, 1872, and passed away in New York on August 18, 1961. He was and is an often quoted U.S. District Court judge for the Southern District of New York and a U.S. Court of Appeals judge for the Second Circuit. I'm going to close with this. What I'm going to do next, I'm going to close with a little statement that I'm going to read. Then I'm going to open it up for final questions and answers, and then I've got a closing statement, and then the tape is over. Okay, here's the what I wrote, a short little piece that I want you to really think about what I wrote here. We here in the United States have been hailed as an honorable and unique people in history because we have used very high-sounding words and stressed high ideals before all the world, focusing upon truth, justice, righteousness, rights, freedom, and liberty as a standard for all nations, which makes it all the more disappointing when we fail to adhere to those very high standards we have heretofore stressed, wrought in the historical record, and declared as the model for all mankind. I'm going to read part of that over again. Which makes it all the more disappointing when we fail to adhere to those very high standards and ideals. Okay, do you have any final questions or anything to address on anything that we stated in this?
Just maybe in the beginning you did a good deal on explaining to people about what you know, how you could give your legal opinion on something, your opinion on something.
Mm-hmm. What about that? Was it unclear?
No. You might just stress that, you know, it's a big responsibility, and somebody should be very careful about doing that if they don't know what they're doing, because it could very badly hurt somebody who listens to them.
Yeah, well, okay, yeah, that's a good point. You know, if you're going to talk to somebody about your legal opinion, and you tell them, well, here's what I do if I was in that situation, be sure you've done a little homework and that you know a little bit about what you're talking about. Because, you know, you're not an attorney, and you're not on the bar, and they can't disbar you, but that doesn't mean that we're out to let people follow something wrong we said and let them get injured or damaged by it. We need to be careful about what we tell people. I'm very, very careful. I do a lot of research. I do a lot of reading. You probably noticed that as you see how I make these tapes, how I read from Supreme Court decisions, how I read the statutes, how I read the law. I've studied the Constitution deeply. I have a whole set of legal books. By the way, I've got here one of books. There's a bunch of books like it over there, but this one here is Trial and Practice Skills, and this is also from West Publishing Company in their In a Nutshell series. And you know, I spend a lot of time making sure that I'm competent at this. I spend a lot of time making sure that I know what I'm talking about. And I realize that if I tell people the wrong thing, even though I read a disclaimer and said, look, I don't want you to come back on me and saying, Pastor Mike said to do this and this, and I did it, and now I'm really in trouble. You know, well, look, I go to a lot of trouble to make sure what I tell you has legal basis and foundation and merit. I go to a lot of trouble for that. And I'm open. If you can show me where I was wrong legally, I'll certainly take a look. Because I'm always open to reproof and correction, always open, even though I know fully what I'm talking about. And I even in some areas, when it comes to these inherent rights and things, I'm sure that I know more than a lot of people out there, even some attorneys. You know, because basically, you know, the attorneys work on the legal conduit that they operate in, and they don't spend a whole lot of time getting into areas that I do spend time in. And so, you know, I don't blame them if they haven't spent that much time in that area. The law is also a specialized profession where you specialize in certain areas of the law. So you can have an attorney who's completely versed on one area of law, but he has to go to another attorney who's versed in another area of law to talk about that. And he says, well, what's the deal on that? I don't spend time there, you see. So we have to be understanding about that. Any other question? Did I address it sufficiently? Okay. So you think I can go ahead and close then? We've pretty much got it. Okay. We're going to close with the closing statement. This has been another Investment in Truth Review instructional video by Pastor Mike Benjamins Jr. of the Remnant Church in Southern Oregon, USA. It is a privilege and an honor to be able to instruct you in so important a subject matter. Thank you for your attention, interest, and consideration and support. This is Pastor Mike saying, take care, and as applicable, God bless.